Hello, everyone. This is your Korean attorney or your future counsel, Hyunchai Isabelle Sohn of InterLEX law firm. And this is Justin, executive at a multinational corporation. How are you, Justin?
Hey, Isabelle, how are you? I remember last time we discussed about foreign companies often complain of the difficulty in managing their employees due to Korea's unique environment. What do you think could be the core issue or fundamental cause of these difficulties?
Very good question. Fundamental cause. What a question. From a legal standpoint, it would be the inflexibility of the termination of employment relationship. That Korea is not an at-will employment jurisdiction. You cannot just terminate an employment relationship due to a redundancy or incompetence. According to the Korean Supreme Court, dismissal is only justified when there is a reason for which the employee is responsible, that the employment relationship cannot be continued in light of ordinary social norms.
Can't be continued in light of ordinary social norms. Sounds like a very vague and tough barrier to overcome. Is there any way to avoid these regulations? For example, as a multinational company, can they just avoid Korean labor law by agreeing on their own country's governing law and employment contracts?
That often happens, but no. Korea's labor law will still step in due to the Act on Private International Act of Korea. Even the parties to an employment agreement choosing an applicable law of another country, that employment will be protected under the mandatory provision of Korean labor law if the employee habitually provides the labor in Korea.
And going back to just cause, what can companies do if there's a very low performing employee? Coming from the US, it's really difficult to expect a company to keep an employee who's been consistently not showing improvement or willingness to improve.
Yes, I recently had a meeting with the CEO of a company who recently came into Korea. And he was very much concerned because of an employee who has been a very poor performer for years. He said, hardworking employees are beginning to think that it is rather unfair for them to be treated equally, and that's harming working ambience.
I remember you mentioned warning letters and PIP programs about this before.
Yes, correct. And that is what we are currently designing for that company as well. Yet PIP program, the performance improvement plan, should not be taken as a measure to dismiss a person. It is an opportunity and a sincere effort to give to employee to improve. And it is the position of Supreme Court of Korea that it was justifiable for a company to take disciplinary action against the employee who failed to improve his performance despite several training sessions under performance improvement program that was implemented due to his poor performance.
I understand. Oh, thank you very much. I've learned a lot through talking with you. Maybe next time let's discuss more about PIP programs.
Yes, sounds like a good idea. Okay, let's do so. Thank you. See you again very soon.